Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In today's episode, we tackle a topic that's been trending globally and one that raises some serious workplace and legal questions here in South Africa. You might have seen the viral video of a CEO and chief people officer caught in an intimate moment on the Jumbotron at a Coldplay concert, and it's ignited a firestorm online, not just for the affair itself, but for what it suggests about trust, power, and accountability in the workplace. In this episode, we explore how a moment of personal conduct when it involves senior executives can spiral into a reputational and legal crisis for an organization. We'll unpack how South African labor law would handle a case like this, the risk of workplace relationships where power is uneven, and whether our current legal framework adequately deals with misconduct that happens outside the office but still affects the workplace. Welcome back to another episode, and today we're zooming in on an office romance that went viral and the legal and ethical implications of an affair at work. Now, you might have seen the footage online. There was an intimate moment between the CEO and chief people officer of a US company caught on the Coldplay kiss cam. And it spiraled into this PR crisis, and an internal investigation was held, and the CEO was placed on leave. Debbie, what are your thoughts?
The classic office romance, and social media has certainly given us all a window into these sorts of office shenanigans. And in this case, it's a great example of the ethical and power and trust dynamics of an affair at work, which inevitably unravels at great cost to a once happy romantic couple. But this was escalated in this case because of the Coldplay camera.
So basically what we're asking in our episode today is, when is workplace romance just that? And when does it actually become a liability? And we want to look at it in the South African labor law context. And, what does South African labor law say about power asymmetries, leadership conduct, and, reputational damage? What does this mean for employee trust and the credibility of HR?
So actually, I think we need to differentiate between different categories of relationships, romantic or otherwise in the workplace. And there are three variables that I think determine these categories. The one is consensus, and whether or not the parties are in a consensual relationship, or whether it's non-consensual and coercive, which would then amount to some form of harassment. So consensus is really important. In this Coldplay case, it appears that there really was consensus. The second variable is one of power. And is this relationship that's playing out, is it one of persons who are in equal power, equal status and rank, and therefore there's not a dynamic of abuse of power? Or is there a power differential between them? Because, of course, a power differential has consequences also for whether or not consensus is true consensus. So I think consensus, the power dynamic are important. And what seemed to be an issue, although, it's not clear from the reports of the Coldplay or astronomer case, the extent to which either or both, I think one of the parties was married, the other was not. But whether or not a third party is involved, that may have an implication for an office romance or an office relationship. So whether or not there's a third party involved, I think those three variables are really important when we consider factual scenarios. So Asha, from your perspective, what are the risks of romantic relationships at work, especially when they involve executives or HR, heads of HR? And how does the law manage this risk in South Africa?
Well, I think romantic relationships at work, particularly, in this case involving executives or HR, I think it raises serious risks when it's tied to power dynamics or this perceived or actual favoritism or bias, and of course the breakdown of trust. And in South Africa, although there's no blanket prohibition on relationships, the Code of Good Practice is where we go to, the Code of Good Practice on the prevention and elimination of harassment in the workplace. And it warns against behavior that actually undermines dignity or contributes to a hostile environment. And if we look at Clause 4 of the Code, it defines harassment to include unwanted conduct that impairs dignity, creates a hostile working environment, and has the effect of inducing submission by actual or threatened adverse consequences. And I think this conduct must also relate to grounds under Section 6 of the EEA, listed and arbitrary grounds. And I think in this case, when, for example, a senior executive or an HR lead is romantically involved, particularly as, she would be a subordinate to a colleague, there is that imbalance of power. And the question then arises whether, is the relationship genuinely consensual? I think in this case, based on how, the video footage was shown, it seemed that it was consensual, but and that's also what makes it tricky, which I think that's what we will go into. But even if the relationship appears consensual, it can create an effect, on this reporting of grievances or harassment, especially where, the individuals are responsible for handling these complaints. I mean, she was HR in the situation. And I think another point to note is the potential liability of the organization, because this is also where the code would state that employers must actually take reasonable steps to eliminate harassment under clause 10. Failure to properly manage romantic relationships where there are things like power hierarchies, it may lead to this breach of duty, particularly where it could foster a workplace culture of intimidation, exclusion, fear. And then, of course, we also look at the EA, the Employment Equity Act, and we look at Section 60, which provides that if an employee commits harassment and the employer fails to take the necessary steps to eliminate this conduct, then the employer will become liable for the contravention in question. And it means that the organization must face legal consequences for failing to act, even if the misconduct stems from a personal relationship. And again, if we have to also look back to our law, we look at the LRA, the Labor Relations Act. We look at relationships that could give rise, and in this case, also give rise to perceptions of bias or preferential treatment. It could also result in disputes based on unfair labor practices. It's relevant where decisions on promotion or performance or disciplinary actions can affect such relationships or are perceived to be. So I think in some romantic relationships involving senior leadership, as in this case, or HR, they're not and are not merely private matters. I think they have some institutional implications that can actually engage on these core principles of fairness and dignity in the workplace. And I think employers should implement clear disclosure and conflict of interest policies. And we don't know what the policies were for the company in question in this case, but for South African employers, they should implement clear disclosure and conflict of interest policies, especially where relationships could intersect when it comes to lines of supervision. So I think proactively managing these risks is essential to ensuring compliance, especially when it comes to workplace relationships. And they have to comply with both the code and the EEA to ensure that integrity.
So in some cases, it's quite clear that relationships are consensual, but there is a power imbalance. And are these sorts of relationships, are they something that an organization should tolerate? And if so, how do we address these? How do we manage this power imbalance where we have this relationship that's consensual?
Well, again, Debbie, I think we go back to the code, and it's clear power imbalances, they can distort consent. I think even when both individuals insist that, look, this is consensual, that's when it becomes very tricky. And the code places an obligation on employers to interrogate whether the dynamics or dependence has influenced that consent. If we look at clause 5.2, it states that previous consensual participation in sexual conduct does not necessarily mean that the conduct continues to be acceptable to the employee. So it's a lot more trickier when it comes to consensual situations. And it just requires that consent is not always static. So they can also be that compromise when it comes to a power differential. I think when it comes to HR professionals, I think the risks are, like you said, more acute. They handle workplace integrity. They deal with employees and they deal with dispute resolution, and they have to deal with the integrity of the company itself. And I think when it comes to this involvement in romantic relationships with colleagues, particularly with an executive or, things that may pose serious threats to institutional neutrality, whether or not there is actual bias, that just that mere perception that workplace decisions might be influenced by personal entanglements can actually undermine trust in the whole entire HR function. And again, the code is very specific about this. If we look at paragraph 10 of the code, it mandates that employers must take all reasonable steps to prevent and eliminate harassment in the workplace, including by adopting appropriate policies and procedures and ensuring that persons in positions of authority or influence are held to the highest standard of conduct. So I think to mitigate these risks, best practice is that employers have to implement clear policies around disclosure of personal relationships that could create conflicts of interest. And I think, whether this is a formal declaration, whether there's, recusal from certain decisions that could involve the potential partner, or even just restructuring, to just preserve that impartiality. So I think if you don't, that's obviously what could lead to claims or, further issues.
You're listening to the Labour Justice Barometer, and we'll be right back.
So I think, just going back to the facts of the situation of this Coldplay scenario, Debbie, would you say personal conduct, like being caught in an intimate moment on camera outside of the workplace, justify disciplinary action or even dismissal when it comes to South African law?
Yeah, actually, I think if we look at the facts and how rapidly events played out in the astronomer Coldplay case, within hours, the company had indicated that there would be an internal investigation. It's clearly that the investigation wasn't around allegations of harassment. Again, we have to keep in mind those differentials. The code is very clear. Violence and harassment cannot be tolerated. An employer must take steps, must eliminate such conduct, must assess the risk of harassment and mitigate against it. So I think, this was clearly a consensual act that this couple was caught in, yet the company very clearly took it seriously, instituted an investigation, put the CEO on leave. And within hours of that, the CEO had resigned. And, within days, the head of HR or people, she had also resigned. So, this for me is suggestive of a very responsive corporate culture. And we know from the literature that sexual harassment and inappropriate relationships thrive when the corporate culture is such that it tolerates that sort of behavior, where harassment is tolerated or discrimination is tolerated. It's the corporate culture that the problem thrives in. So it's reflective of a good corporate culture. In the South African context, I think if there's harassment, our case law has shown that because of the code and because of our laws, we do take sexual harassment seriously. What would have happened in a similar case in South Africa? I think if it's very clear that there's a breach of a conflict of interest, or if the misconduct, results from a failure to use policies and report on the reporting, the needing to disclose personal relationships is also, it's controversial, where particularly if the workplace relationship doesn't create a conflict of interest, then requiring employers to disclose can be a breach of privacy and invasive. But where there's a threat or a risk of conflict of interest, then disclosure should not be, a problem. And I think a company could justify disciplinary action or even dismissal. But whether that would have been the case if this, for example, was a South African case, I'm not convinced that our companies would have been as responsive as Astronomer was. And that might be reflective of the state of our culture. And, we've seen this. I'm not going to comment on our own judicial conduct tribunal proceedings that are unfolding because it's argued whether or not it was a case of consensus, but it clearly was an allegation of sexual harassment. The Judge Selby Benenga case involving his secretary. And we're both in the legal profession, and there's several workplaces that I've been in. Certainly, this is not an unusual factual scenario where there's an abuse of power over a junior in a secretarial or administrative position. And I have to say, also in my own experience, often these relationships may start with an element of consensus, but become something completely different. And you've spoken about that earlier when you spoke about the code, recognizing that consensus can change. But we see in these cases, and we see the extent to which culture and our cultures, we know that our society is one where gender-based violence and sexual harassment are frequent occurrences, that our culture perhaps is not on a par with that which we saw in the swift action of Astronomer. So yes, that's a long answer to your question around whether this could justify disciplinary action or dismissal in South Africa. I think it could. On the grounds, certainly if it's consensus, we have to look for other grounds, conflict of interest, in breach of company policies, but those policies must also not amount to overreach of a person's private life, where there's no risk of harm to the company. There may be overreach, but certainly, if the conduct has impacted on the employment relationship and there's a breach of trust or conflict of interest, this would justify disciplinary action or dismissal even.
Okay, so Debbie, in your opinion, does South African law actually need to do more to regulate conduct outside the workplace when it has workplace implications? And, what should employers do when it comes to this element of trust in leadership, and when it actually breaks down due to personal misconduct? What should actually employers do in these cases?
So I'm wondering if this is a question of law or whether this is a question of conduct and workplace policies, which might, arguably be a question of law. Should our law be more specific? But I do think our legal framework is very clear. We have the code, which certainly is responsive to aspects of workplace relations involving harassment. Have companies regulated relationships outside of harassment to the extent that they could? I'm not convinced. I'm not convinced that we have, but I might also not be, up to speed with how workplaces and organizations are managing personal relationships. But the workplaces that I have been, there certainly has been room for greater clarity also. I think employees would welcome clarity in many cases around what is acceptable, what is not acceptable. And on that, employees should also be obviously party to those discussions and deliberations around the development of workplace policies. My own marriage is founded in a workplace relationship, but one that had no power dynamics and no impact whatsoever on the work being performed in the organization. I think we probably, haven't prioritized workplace relations. And I know that in some organizations, there may well be policies in place for reporting of relationships. Where there are not policies in place, I think if employees are concerned about whether or not their relationship will be perceived as having an implication, questions around trust and questions around conflict of interest, as you mentioned, for example, a person in an HR position, a person in a decision-making capacity may well favor, parties that they're in a relationship with. Favoritism is not, although I think our code does mention favoritism, but in other jurisdictions, there often are not rules against favoritism, not legal rules against favoritism, at least. And so, if a company, wants to protect themselves from that sort of conduct in the workplace, they do need to be explicit on what the rules should be. I'm not sure whether it's always tricky for the law to step in and overregulate the private realm of relationships. The one aspect that we've not touched on is the third variable, which I mentioned. The first being consensus, whether or not there's consensus. The second, whether or not there's a power relationship, and the third being whether or not there's a third party involved. Because I do think that has a bearing on the trust relationship. And a person in the workplace who's in a marriage or in a permanent partnership or a long-time partnership, that relationship might, be one of an open relationship where both parties, agree or tolerate workplace romances, which would be different to a marriage where there's a contractual relationship between the parties, and what appeared to be the case in the Coldplay matter, where the parties hid. It was clear that they did not want to be seen either by the company or perhaps by a spouse or a partner. That also has implications for a person's integrity and trust and their character. You obviously know that you're in breach, you've been caught in the act. If a company wants to use information like that or bases their relationship on trust and character, particularly of persons in leadership positions, it is better, I think, for the company to be explicit about it rather than to rely on abstract principles of trust. But whether or not it's a question of law, I think that's debatable and maybe something we can unpack as well in future episodes. And I do think, and we can discuss this again. We have raised it in one or two of our episodes. But coming back to the question of a breakdown of trust and intolerability, and what that means for different positions. Whether you're in a position of leadership or in a position of power, what does it mean when a relationship becomes intolerable because of the conduct of the employee?
Even though this is a Coldplay concert incident and it seems meme-worthy and it's, everyone is talking about it, it's trending, it actually opens up important questions in the workplace regarding leadership ethics, personal conduct, and how it intersects with trust. And I think we should definitely look at in future episodes as well. And also about neutrality and when it comes to HR neutrality as well.
I think an important part of the inquiry also is corporate culture. I know this was consensual and that is different, but I think it's really important that corporate cultures start to change. And in many cases, we are seeing this as the norm, that sexual harassment won't be tolerated. And perhaps it's about extending that to all relationships that might impact on employment or the workplace. Aisha, thanks very much for an interesting discussion and look forward to speaking to you soon.
This podcast is not intended to constitute legal advice.